We are here today on State versus VanMeter. Each part will have 50 minutes to argue. In this case, there will be no asking of you for rebuttal time because you're the only person arguing at the appellate waive, so you'll have your full 15 minutes. The arguments are being recorded as I indicated. Please make sure you introduce yourself before you get started. Please keep your voice up and remain behind the podium. You do not use the names of children, minors, and victims during your argument. You can refer to them by initial or term like the child if you need to in this particular case. Such as I've read your brief and I'm ready to proceed when you are.
Thank you, Your Honor. Joy Wagner on behalf of the appellant Jack VanMeter. This involves 4 separate cases that took place over a period of about 3 years. I'm going to be referring to the chronology of events that was rejected by the magistrate because honestly it was the only way I could understand this case because so much happened. I think there were 60 hearings total, several trips to North Coast Behavioral Health, multiple continuances, mix-ups on where he was supposed to go, to the psychodiagnostic unit or to North Coast. So I'm going to be referring to this, and of course it's also important as to my speedy trial argument because I think Judge McLaughlin even stated that the speedy time counter was a mess and they were going to have to figure it out. So this is the only way I could figure it out. So I would just ask that the court reconsider utilizing this. I know someone from the court is going to read every one of these transcripts, but this was very helpful to me. My main argument today is going to be regarding Mr. VanMeter's competency. The other thing that this is helpful for is I realize that it can be harmless error if there's not an indicia of incompetency. I read the case that the state just filed, it was just decided on the 28th of December, State v. Mills. Because the reason every transcript and every order is important is because that indicia is just not what Mr. VanMeter said and did to the 3 years that the court and the state had contact with him. And those 4 cases, there was relatively no time in between when he was released from jail and when he was arrested, from 3 days, I think, to 2 weeks. So when you look at the chronology of events, not only do you see that behavior and the statements of counsel, oh, he's hallucinating again, oh, he's decompensating, oh, you know, he can't be evaluated because he was hallucinating at the time. In addition to that, look at the subtleties in his behavior and what happened, and look at the pattern of things that happened. When I'm talking about subtleties, for example, he was referred to the SHARP program, I think 5 times. That's that program for, your court's familiar with that program. Even on the last day of all these proceedings at his sentencing on the last charge, he was still thinking he was getting into the SHARP program. Even though he had been rejected by the SHARP program multiple times with Oriana House and the SHARP program saying, we can't accommodate his mental illness. Where's he going to go besides jail? He should have gone to a psychiatric hospital so that they could stabilize him and for how long it needed, because he was never stable during the proceeding. And I point out in my brief and also in my response brief just really a litany of all the events that occurred and the patterns that were going on and his behavior at certain points in the proceeding. Due process requires a court to hold a hearing when it has been presented with sufficient indicia of incompetence. That's the main relief we're requesting, besides the speedy trial issue, of course, to dismiss, is that he needed to have a hearing. He should have had a hearing where witnesses could have been called. Witness, for example, from somebody from the SHARP program to testify how a person who cannot even live in a structured group home for the mentally ill, he cannot fit in there. How does he have the skills to not only live independently, take care of his needs, but also take care of his legal needs, which probably are the most complex of all?
Counsel, how do we square the state makes the argument that the comp evals that the court had in front of it at the time were stipulated to?
They weren't stipulated.
Okay. It is
They
just
weren't all
an argument.
stipulated
Okay.
to. They weren't all stipulated to, and I point that out in the chronology in the one area. But as far as this case goes,
When we say this case, it's the
When I
most
talk
recent, the most
the
recent
most
case.
recent criminal charges.
Okay.
Correct.
Just to clarify when you say that.
Right. Thank you.
Because you are correct, there are a lot of things in this record, I'm assuming.
Well, at that last hearing, the most recent case where he had gone, he'd been sent to North
Right.
Coast to be restored, and then
Correct.
he came back, and there was a report, I think the prosecutor alleged that there's a report that he was deemed to be competent, and there was a hearing date set. So was that report stipulated to for that particular hearing?
I will look that up.
And
I would say one thing. I think it would be, I don't know why anybody would have stipulated to that report. And this is why I say that. Dr. Stankowski had the following opinion, that he had been restored to competency at this time. That's important. That's what I'm saying. Look at a pattern, because he goes from competent to incompetent to competent to incompetent over a 3-year period. Now, how at the end of that is a person competent, especially when he says, I'm still hallucinating? At his sentencing on this last criminal case, he said, I'm going to try the best I can, I'm going to try to do better, I'm going to try to control the voices, but I'm still hallucinating.
At the time of his plea in this matter, in the most recent case, at that hearing, were there indicia of incompetencies at that hearing? In other words, we take this plea, did he appear to be competent at the time they took his plea? Did he have questions? Did he seem to interject into what was going on?
This is what I wrote in the chronology based on the plea hearing. I read all the transcripts, by the way. This is plea in case number TR 2020-12-3565. He again wanted to know what he was being promised, and the court continued its attempt to make it clear that nothing regarding sentencing had been promised and that additional information was needed before Mr. VanMeter could be sentenced. And what she's talking about is the SHARP evaluation, the one that he's been totally rejected from. Upon the return, the court explained, he has to talk to counsel at the plea hearing. Upon the return, the court explained which charges Mr. VanMeter would be pleading to, the potential penalties and the rights that he would be waiving. He entered a plea of guilty. However, he still did not comprehend that his admission to the SHARP program was not a certainty. At the conclusion of the hearing, he seemed surprised that he was not getting out of jail. He thought he was going into the program. He was on probation. He thought that his release, and I think these are pretty close to his words, had been part of the deal. And he demanded an appeal of his plea. That's not understanding the proceedings. If you think you can appeal after your plea but before your sentencing. Now, it could be that he was incarcerated again because, according to Dr. Stankowski and Dr. Testa, his stability was really entirely dependent on his environment, which was not the jail. The jail said is where he decompensates and begins hallucinating again. And I also learned that there's a policy at the jail that if you try to not take your pills, you can never have that pill ever again. And that happened. In fact, at a plea hearing in one of the other cases, he tells the judge, the jail, they took me off my medication right before she released him into the community. He was not being medicated. I'm probably close to my 15 minutes. Unfortunately, I'm not sure I would have consolidated these cases because I probably could talk for another hour on all this. But I ask you to please look at Dr. Stankowski's opinion. You just have to look at the transcript, and I'm sure the report is in the court file, and Dr. Testa. And it wasn't all his fault, if you're going to look at that. It wasn't necessarily that he didn't take his medication. It was that whatever environment he was, the jail, refused to give him the medication that was prescribed. And if you look closely at what Dr. Testa said, medication wasn't always effective for him. And that is true of some people. They spend their entire lives, because he's dealing with something really serious. He says he's a paranoid schizophrenic. And when faced with incarceration and homelessness, he always chose the wrong thing. He chose incarceration. He basically lived at the jail for 3 years. On the speedy trial issue, again, the chronology, I track all of the time between events over all 3 cases. And in my response brief, I do the argument about what amount of time should be attributed to the state, and which amount of time should be attributed to the defense. So unless the court has any other questions.
On the not guilty by reason of insanity issue that you raised, was there a not guilty by reason of insanity defense entered in the most recent case?
Yes. Motion was filed.
And did the report, when he spent a time in North Coast, give any indication of whether the folks there felt he was?
Nobody said anything.
Did not say anything regarding that issue?
No one said anything about at the plea, at the sentencing, throughout the proceedings. It just got kind of lost in the shuffle. And I think there's a defense there if you look at his behavior. So, thank you very much.
Thank you. And thank you for your presentation. The court will take the matter under advisement, issue decision in due course. The clerk of court will mail a copy to you at the day the decision is released. The opinions are also posted on the High Supreme Court website.